Hi, my name's Clare Murray. I'm managing partner of specialist employment and partnership law firm CM Murray, and this is the second in our two-part 10-minute talk series on the SRA consultation. And I'm delighted to be joined by my partner, Andrew Pavlovic, who is our specialist regulatory and professional discipline partner. And I wonder, Andrew, can you tell us what it is we're going to be talking about today?
Yeah, so today we're going to be talking about fitness to practice and the SRA's proposals in this regard. And they are, in summary, two proposals. One is to introduce into the assessment and character and suitability rules a requirement that an individual self-authorises or lets the SRA know if there are any health issues that could impact on their ability to practice. And then the second stage would be the change to the authorisation of individual regulations. And that would amend the regulation to make clear that the SRA may refuse to issue a practising certificate or impose conditions on a practising certificate to address fitness to practice on health grounds, i.e. if someone is not fit enough to effectively to either perform the functions of a solicitor or be subject to regulatory investigations or disciplinary proceedings.
So when I read this felt to me very much like a kind of a bit of regulatory whack-a-mole by the SRA, in that they've clearly had a number of recent cases over the last just recent months, but also the last couple of years, which just seem to resonate. The outcomes seem to very much resonate with some of the issues in this part of the consultation. So I don't know. I know that's somewhat flippant on my part, but I wondered what your thoughts were on that, Andrew.
No, it's definitely fair to say that this does seem to have been prompted by a number of recent cases where individuals have said that they're too ill to participate in the disciplinary proceedings, and Article 2 rights, i.e. the right to life, would be engaged if they were required to carry on participating in those proceedings.
Right.
And the problem that creates for the SRA is that you have someone who has a practising certificate, who's able to practice as a solicitor, but is effectively immune from prosecution because they're able to demonstrate that they can't be prosecuted because they'd be at risk of a serious psychiatric issue or another health issue, such that they can't be prosecuted.
So they can sort of go ahead with their day job. They're well enough to go ahead with their day job, but not well enough to participate in any sort of regulatory disciplinary process.
Yes, and obviously that position would only be reached if the individual was able to demonstrate with medical evidence that that was the case, but it still creates potentially this lacuna where someone falls outside of the sanction of the SRA. So I agree that is definitely a driver, but this is also not a particularly new issue. It's very common in other regulatory fields. Barristers have a fitness to practice panel, the General Medical Council has a fitness to practice regime, and it's there to ensure that where someone is unable to practice effectively, that's treated sympathetically, and they may be suspended for a period of time whilst they get treatment, including, for example, if they have an addiction problem. Whereas in the SRA cases, we tend to see it at the point when regulatory misconduct occurs. People are brought before the tribunal, and then they're saying, well, actually, I have this health condition, and that condition is either relevant to the offence itself, i.e. they say, well, I committed this act of dishonesty because at the time I was suffering from a health condition, or they say, because of this health condition, I can't be subject to the process. The tribunal themselves actually recommended, I believe in 2019, that the SRA look at introducing a fitness to practice regime because they were seeing all these cases come before the tribunal with people raising ill health as a mitigating factor.
I mean, in reality, do you see many people who are going potentially before the SDT and are raising health issues? I mean, how often do you actually still see them functioning otherwise back in their day job? I mean, are they not normally on sick leave anyway? Or do you see people kind of continuing with the day job, but staying. I can deal with that 90% of my job, but because of, say, my mental health condition, I find this process triggering, and that's what I can't deal with. I would have thought they're probably on sick leave anyway. They're probably not practicing anyway. If they're also saying that they're not well enough to attend the tribunal or engage with it.
Yeah, I think that's a fair observation. And, having acted for a number of individuals that have been subject to investigations and prosecutions, I think it's stressful for anyone, regardless of whether you have a health condition. And then if you had a health condition on top of that, it's going to be hard to concentrate and do anything else anyway.
Yeah.
So I do understand the point that in reality, how many people are actually out there able to practice but not able to participate in disciplinary processes. It may in reality be a relatively small number.
In addition to the abilities to suspend that's being proposed, are there other sort of interventions that they're proposing as well?
Yes.
Maybe that are slightly more or less draconian than suspension might seem.
Yeah, so suspension of the practising certificate is just one of them. So the other thing that's mentioned is imposing conditions on a practising certificate. And there wasn't a huge amount of detail in the consultation about what that could involve, but it might, for example, require someone to not be in a position of like a culp or a cougher, or to make sure that they're supervised, or that they have undergo particular courses of therapy or addiction treatment. So it's not just a blunt instrument necessarily of removing someone's ability to practice. There may be conditions that can be imposed alongside that, because obviously there are lots of people that might have health issues that are perfectly able to practice and to function. What we're talking about here is where the health condition has got to the point where they cannot exercise their functions as a solicitor effectively, and that they are, as a result, a regulatory risk.
And presumably, if the SRA does go ahead and make these changes, it'll be important for firms to ensure that their partnership agreements and their employment contracts are updated to give them some flexibility to support and implement the qualifications and these, I guess, restrictions, let's call them restrictions, although they might feel like sanctions, that the SRA is proposing or is imposing.
Yeah, they'll need to be aware of that, definitely. And also, obviously, in any event, they'll need to be aware of general health issues that could be impacting on people's ability to practice from their own risk management perspective. But also this additional angle that could feature now of someone being taken out of the picture temporarily. I mean, it's made clear in the consultation that they're not envisaging striking someone off the roll because they're unfit to practice. It would only ever be a temporary measure that would be reviewed on a regular basis. But yes, employers would need to be aware of this and what they could potentially do to mitigate that if it happens.
So what I'm hearing from you really is actually what the SRA are proposing here. It's not groundbreaking. It's actually pretty much in line with what other regulators have had for a long time, and it's just making sure really that firms are prepared for it, and individual sort of lawyers understand that this is part of the range of options the SRA will have available.
Yes.
And maybe that if there are ill health issues, that they need to be, it's probably going to be in your best interests to articulate these with your firm as well as with the SRA at an earlier stage.
Absolutely, because a key aspect of this is misconduct occurring and then health issues being raised in the course of tribunal proceedings. So the idea is you sort of nip it in the bud, but obviously that does require the individual themselves to recognise that they are struggling, and to be able to have that conversation firstly internally and then obviously with the SRA as well.
It's a balance, isn't it? It's the individual feeling safe that they can reveal this information and do it in a safe way, and they won't be in any way penalised for it. But also, there are obviously obligations on firms to, provide a safe working environment, to undertake risk assessments, and there's some very good work being done in terms of training partners and professionals within firms to help spot health issues within their teams. Is there anything else that you would suggest, whether it's the SRA in terms of their consultation, or in terms of or to partners or people, professionals in law firms?
Just a reminder that the consultation is open until the 27th of May, so there's a chance to respond if you'd like to do so. I think the proposals in terms of fitness to practice are fairly modest. They're not, as I mentioned, other regulators do, introducing a completely new fitness to practice regime or fitness to practice panels. So I think it's a welcome intervention into this area. Addressing ill health is important at an early stage, and it will only work if people are willing to address that themselves, and there are obviously challenges there. But I do think it is worth looking at, and I think it is worth introducing.
And doing it also against the backdrop of disability discrimination, as well as other employment protections and the obligation to make reasonable adjustments. And those obligations will not just be on the firm, but also on the SRA, as a public body. So yeah, this is so interesting and really important. I really appreciate it. Thank you. And I've sort of learned a lot from our sort of little mini series. So thank you, Andrew. I hope you've enjoyed this discussion. And the issues and some of the points that we've debated. If you have any questions, please do get in contact with us. I know Andrew would be delighted to speak with you, and he loves talking about these sort of issues, or anything else regulatory and professional discipline related. If you enjoyed this, then, as they say, please share, please like and subscribe, all of that good stuff. But thank you again, and hope you have a great day. Thank you. Take care. Bye.